Hello, everybody. I'd like to say it's nice to see everybody, but I can't see everybody using this methodology. But I hope everybody is doing well, or at least the best that they can be doing in these trying times. Uh, I wanted to come to you today to bring you some very useful information. Before I do that, though, I really want to take a moment to acknowledge the people that are out there on the front lines, our nurses, our doctors. They're doing things for us right now that are saving lives. And anything that I can do to help those people, please contact us. But we wanted to come to you today and share with you some very useful information that I think is important because this is what we're hearing from the people in the community. Everybody should know that there are certain documents that you should have that consist of your estate plan. Very simply put, a power of attorney and a statutory gifts rider, a healthcare proxy, and a last will and testament. These are very basic estate planning documents that, unfortunately, a lot of people don't have in place. And what we're hearing from people that are calling during these trying times is that they're scared. Many people are sitting at home watching the news, watching the numbers rise on a daily basis. There's relatively little good information out there right now. And it's scaring a lot of people that they don't have their plan in place. And they're real fears. This is not something that we can just dismiss and say, oh, you worry too much, or oh, you can take care of it later. This is something that really should be dealt with now. And a lot of people think that you can't do your estate planning now because you're sequestered at home and you can't leave your house, or you shouldn't leave your house other than for the essential food shopping or a doctor's visit or things like that. And I'm here to tell you that that's not true. There have been some changes in the New York State laws recently that allow us to help you, and you don't need to leave your house. 2 weeks ago, almost 2 weeks ago, Governor Cuomo issued an executive order. That's when Governor Cuomo can act on his own. And the executive order allows us, not just we attorneys, but any notary can notarize documents remotely now. So we're going to talk briefly about those documents that I mentioned that are some of your base estate planning documents, but let's just take something very simple as a deed. A deed has to be notarized. When you sign your deed, we as attorneys, we say it has to be acknowledged. So you need to have a notary that stamps it, and that's the final act of drafting a deed. Well, if we can set you up in your home with video, a lot of people are using Zoom, you might use Skype, some people just use their phones, their cellular phones. If we can set you up with those technologies at home, we can watch you from our setting. It might be I'm working at home or wherever I am, and we can watch you sign the document and notarize it remotely. That's a really important change in this crisis right now. That was good. It was a good act by Governor Cuomo, and it really allows us to help people that don't have their planning in place. There are some other things that are still a little uncertain. For instance, there's no executive order that speaks to witnessing documents. So if we talk about a will for a moment, a last will and testament, a last will and testament has to be witnessed by at least two individuals. It could be three. And generally speaking, the statute says that in order for us to witness a last will and testament, we need to be in the presence of the person that's signing their last will and testament. There's arguments that we're making as attorneys that right now we're in each other's presence. Right now, that's not in the statute. There's no case law on this. There's no executive order. We think that there will be an executive order or something that would be that might be forthcoming from the New York State, whether it's Cuomo or a change in the law that allows us to witness remotely. With that also being said, a lot of other states have already addressed this issue. And so it's becoming common practice now in other states to be able to not only notarize a document remotely, but to witness a document remotely. So what we're doing right now as elder law and estate planning attorneys, we're trying to be proactive. We're trying to help you. We are always here to help you. And that's not a salesman pitch. It's truly in our nature. We have a small office, but we have very dedicated staff that really cares about your needs. And there's no better feeling than having somebody like an elder law attorney, like an estate planning attorney that can say, hey, listen, I'm going to help you. I've got this. There's no need for you to worry anymore. And that's the message that we're trying to get across to you. Don't sit at home fearful of what might happen next. This virus can affect any of us. And I'm not using the virus to sell my services, but it is reality. And this is not going to go away fast. People are talking a month, people are talking 2 months, many people are talking for a longer period of time. Let us try to help you cure some of these anxieties that you have. Anybody that is listening to this video, whether it's live or thereafter, sometime in the future, should not be without an estate plan after listening to this. If you choose not to work with me, find somebody that's capable of providing these services. Not everybody's capable of providing these services. We are set up to do this. We are fully functional. We're working remotely in most cases, but we can help you. So with that being said, that's the primary message that I'm trying to get across. I'm happy to answer questions that anybody may have, whether it's live or if it's after the fact. I am going to end at 2:30 to be respectful of my associate who's videotaping this conference, and also everybody else has time commitments, whether it's you're taking care of your kids or a loved one, or you have to cook dinner, or whatever the case may be. You might be working at home, but I'm happy to answer questions after this video ends. Let's talk just a little bit about the documents that I mentioned. I want you to understand the breadth of some of these documents. It's not good to draft a document that you've printed off the internet, unless, of course, I emailed you the document. But a lot of people do, whether it's because they want to save legal fees, or they're just ambitious to do things on their own, or they just may not like attorneys. We are good attorneys to work with. An elder law attorney, an estate plan attorney. I happen to be an accountant as well. We're out there to put together a plan for you that makes sense and brings comfort to your overall financial plan and to your goals and obligations. So the power of attorney is a document that, unbelievably so, many people don't have. And it's probably one of the most important documents that I can draft for you. It's taken for granted on a regular basis. If people do have a power of attorney, it's often obtained from sources that are not as credible as an elder law or an estate planning attorney, and it's often drafted off the internet. A power of attorney is the document that allows somebody to handle your financial affairs, and also some non-financial affairs. For instance, a power of attorney, if drafted properly, it allows the agent that you appoint to set up a trust on your behalf. It allows the agent to change beneficiary designations. It allows the agent to do things from a Medicaid application perspective. It also allows the agent to go to the bank on your behalf and handle your financial affairs, sell your property, pretty much anything you can do from a financial perspective. The power of attorney, the agent under the power of attorney can do if it's drafted properly. And that's a big if, because I would say about 2/3 of our practice is dedicated or devoted to trying to fix powers of attorney that were not properly drafted. What do I mean by a properly drafted power of attorney? A properly drafted power of attorney is modified. So if you go onto the internet and print out the form of a power of attorney, It's going to be your basic statutory form that has, a whole host of powers that are you're going to recognize them very easily. A good elder law attorney or an estate planning attorney modifies that form to add powers. We add things like gift-giving provisions. We add things having to do with Medicaid planning. We add things giving the ability to create trust. The power of attorney in its basic format is actually, I don't want to say useless, but it's very deficient from a planning perspective. And a lot of people might say, but I don't understand. What do you mean? My daughter goes to the bank for me all the time. Well, a power of attorney that's properly drafted is really two parts. You have the power of attorney, which has your administrative powers. It doesn't have anything to do with moving your assets around. It doesn't have anything to do with changing your beneficial interest in anything. It's opening a bank account, closing a bank account, creating a trust. These have nothing to do with the money that's in your name. There's a second piece of the power of attorney that's called a statutory gifts rider. And this is what people don't have. In order for your agent to be able to move your assets around, transfer your assets to a trust, change beneficiary designations, they need to be on a statutory gifts rider, and that statutory gifts rider needs to be modified by somebody like me putting those powers in there. So the basic form is very bland. It doesn't have all the different modifications that may become useful later on down the road. Here's a perfect example. Mom and dad are at home. Mom needs care. Maybe she's got dementia. And we need to put an aid in place to help take care of mom. And we want to move mom's assets to dad. And we're allowed to do this under the laws, although the laws just changed today, and I'm not going to get into that, but the Medicaid laws, on top of this big coronavirus, they just changed the Medicaid rules as they apply to home care cases. But we can always transfer assets between husband and wife. But let's say there are assets in mom's name, dad's not on the asset, he's not on the bank account, and she's lost her capacity. We can't move those assets unless we've got a power of attorney. And not only do you need to have a power of attorney, but there needs to be modifications in that power of attorney allowing for the agent to move an unlimited amount of mom's assets. And this is what's missing from a lot of people's plans. And there's a procedure for setting this up that needs to be followed. For instance, if you drafted a power of attorney and you're listening to me right now and you say, oh, Sal, I don't have a statutory gifts rider. We have to go back and we have to redo the whole thing. You can't do a statutory gifts rider by itself and add it to a power of attorney later on. These are just some of the nuances of the law. And it really drives home why you should not be doing this off the internet, because the internet is not going to teach you some of these nuances. But a power of attorney is extremely important. It's what allows us to help your family later on down the road. If we don't have a power of attorney that's been properly drafted, or we don't have a power of attorney at all, then the next step is a guardianship proceeding. And that's when we've got to go to court with your family and get somebody appointed to be the guardian of your affairs, so that way we can then go and move the assets and do things like that. So the power of attorney is extremely important. And with the new rules or the executive order in New York State, we can work with you while you're sitting on your couch at home to sign that power of attorney. We would initially have a consultation over the phone. We have documents that we want you to fill out that all can be transmitted via internet. And then we can draft the documents and email them back to you, and then attend to the signing of the power of attorney remotely. The power of attorney requires witnesses, just like a will. So we're going to be in that situation again where if we remotely witness the document, what happens down the road? Well, like I said before, we're expecting that should be addressed. And if it's not, we're keeping a summary of everybody that works with us during this crisis, who have signed documents that were remotely witnessed. And what we're most likely going to do is ask you to come back and re-sign those documents when the coast is clear. But at least we've got something in place, and I will defend it to the best of my ability. And at least we have something in place in case something bad happens.
I have a question.
We have a question, so I'm happy to answer a question.
So this is from Josephine Canzano. Are these documents standard, or are they different state to state?
Hi, Josephine. That's a good question. These documents that I'm speaking about are specific to New York State. Now, every state has their own power of attorney, healthcare proxy. They all have their own laws governing these documents. But what I'm speaking to is limited solely to New York State. And I'm not going to get into whether the document is effective in another state. It could be effective in another state. But right now, everything I'm telling you is New York specific. Let's talk about a healthcare proxy briefly. I'm not going to spend a lot of time talking about a healthcare proxy. It's somewhat of a basic document. In this office, we keep it very bland and simple. The healthcare proxy appoints somebody to make your medical decisions if you cannot make your own decisions. We all have a constitutional right to make our own medical decisions. But when you can't make your decisions, your agent under a healthcare proxy stands in your shoes. And there are statutes actually in New York State that allow for somebody to make your healthcare decisions in the absence of a healthcare proxy. But we don't want to rely on statutes in New York State. We want to draft it the way we want to draft it. We want you to be able to appoint the person that you trust, so that way your medical decisions will be carried out. The healthcare proxy is extremely important, and we do that on a regular basis. And that requires 2 witnesses. The next document is your last will and testament. Your last will and testament, everybody knows what a last will and testament is. And if you don't, ask us the question. I'll be happy to get into more detail. But your last will and testament governs the disposition of your assets upon your death. Most people, if not everybody that I work with, has a last will and testament. One of the problems with a last will and testament, and maybe it's not a problem in all cases, and it's not a problem in all cases, but it has to be probated. And if you've ever been through the probate process, you know that dealing with the courts could take a long time. There's a lot of red tape sometimes with the courts. We're very fortunate here in Westchester County to have an excellent surrogates court system. But even with that system in place and the wonderful people that we work with, it still could take quite some time to probate an estate. And there are instances when you just don't want to go through probate. So if you have a regular estate, maybe it's not that big of a deal. But if you're somebody that owns property outside of New York State, we just picked up a client yesterday, believe it or not, who owns property outside of New York State. When you own property outside of New York State, generally speaking, we have to probate your will here in New York, and then we've got to go to that other state, hire competent counsel in that state to do it again for that property outside of New York State. When I see fact patterns like that, I encourage you not to have a last will and testament. Well, we would still have a last will and testament, but I encourage you to have a revocable trust. You may have seen revocable trust in the news. People deliver things to your mailbox all the time. The main point with a revocable trust is that it avoids probate. A revocable trust avoids probate. What does that look like? It's a document. It's no different than a will. It's a piece of paper that says, when I die, do A, B, and C. But in order for the revocable trust to work, my phone has to be in the revocable trust in order for it to be governed by the revocable trust. My house needs to be in the revocable trust in order for it to be governed by the revocable trust. And a lot of people draft these revocable trusts because you might have been to a seminar, you've drafted it, but you've never funded it. And that's a big deal. And I want you to take that home. If you have a revocable trust, you need to make sure that your assets have been transferred to the revocable trust so that way the trust works. If your assets are outside the trust, we're going to be probating. We're back to the will. And so the money that you spent on the trust is wasted, and we're going to go through the probate process. There are other instances when a revocable trust is a necessity. Perhaps you have a disabled relative that you're leaving assets to, and we want to set up a special needs trust. Or maybe you have minor children or adult children that you're setting up trust for. Maybe you have no close living relatives. Maybe the nearest living relative is a cousin that you haven't spoken to in quite some time. These are reasons to stay out of the court system. These are reasons to have a revocable trust. And I'm happy to discuss that with you. Ironically, the revocable trust is probably the easiest thing that we could do remotely because you don't need any witnesses. You just need to sign the trust, and I need to notarize it. Finally, not for everyone, but there are a great deal of people out there that should be thinking about long-term care planning and protecting their assets if they need care someday. So you may need nursing home care someday. You may need home care someday. And I don't need to really get into that to sell it to you. What we're going through right now speaks for itself. But a lot of our practice is dedicated to trying to save people's assets in the face of long-term care. And if we have the opportunity to work with you in advance, well in advance of needing care, I could save a lot of assets by using trust. We could also help you save assets even when you haven't put the planning in place. It's just that we may not be able to save as much, and it may be a little bit more of a rough road. But a lot of people are considering Medicaid trust because Medicaid is one of the resources that people rely on to pay for nursing home care and home care. If you are somebody that needs care someday, whether it's in a nursing home setting or a home care setting, there's really limited options for you to pay for that care. The first option is to pay for it yourself, and it's very expensive. If you've got to pay for a nursing home today, it's in this area $15,000 a month, and you could go through your assets very quickly. The second option might be long-term care insurance, but we're finding that not many people are willing to buy long-term care insurance because it's expensive. There are underwriting requirements. Maybe somebody has health concerns that disqualify them. Anybody that has long-term care insurance for a while now knows that in many cases the premiums have been increased, and if the premiums were not increased, the services were decreased. Medicare is an option once you reach a certain age. But Medicare only pays, at best, for the first 100 days in a nursing home. And it could be cut off a lot sooner. So those are three options that none of those options sound great. Medicaid is the last option. So we work with a lot of people to try to avoid them having to deplete their resources by privately paying. Most people that we see don't have long-term care insurance, but if they do, we're still doing the planning because long-term care insurance can run out. What if you start using your long-term care insurance and you've got one of these cognitive impairments that takes a while to progress and you need to use the insurance policy? What happens when you run out? And Medicare is not something we rely on. So Medicaid is what we do a lot of in this office. An elder law attorney does Medicaid planning on a regular basis. And to set you up well in advance for Medicaid, there's a Medicaid trust. And the Medicaid trust is an irrevocable trust. A lot of people get scared when we say irrevocable, but you should not be scared, especially in today's climate, because that's what's going to save your assets. There's a 5-year look-back period. And if you can get past the 5-year look-back period after you set up the trust, whatever we put into that trust is off the table. Medicaid will not touch it. When we talk about look-back periods, the laws that were just changed, and I just read it today. I mean, we knew it was coming, and I have yet to really study it, but we believe that the look-back period now for home care is 30 months. So it used to be that there was no look-back period for home care. So you can come in today and tell me about your mom that needs care at home, and we can move all of her assets to anybody that we wanted to, a child, a spouse, a trust. And if we did that by the end of the month, then the following month, she would be eligible for Medicaid home care. That's not the case anymore. And if you're listening to this video, I want you to pay attention to that and share that word to whoever you know. It means that you need to come into this office or another elder attorney, but I hope it's me, and we need to do your planning. We need to set up trust and move the assets. But we're just hearing about this. We're reading about it today, so it's going to take a little bit of time for us to digest it. I want to invite everybody to sign up with our Facebook page. I'm going to do my best. These are changed times. I'm going to do my best over the next, I can't even say how long, everyone. It might be a month. It might be 2 months. But I am going to do my best to educate you on whatever information I think is useful. It might be something as simple as me videotaping myself in my phone and sending it off to everybody. It may be something like this. In fact, next Thursday, we're going to do this again. And we might have some facts, real fact patterns, real cases to share with you. Or maybe there's some other things that we want to talk about. And if there's anything that you want me to talk about, I'm happy to do so if you send me an email. And in fact, it makes my life easier because I love answering questions. And if you send me questions, I'll make a half an hour session maybe out of the topic that you want me to speak about. But please sign up for our Facebook or go on my website, which is Plan Today for Tomorrow, all spelled out, Plan Today for Tomorrow. You should sign up for our newsletter. We just sent one out yesterday. But if you sign up, you'll be on my distribution list. And we do send out really good information on a regular basis. And that's the best way for us to stay in touch with you. You may not call me up today or tomorrow and hire us and use us for our services. But if we're there for you, if we're giving you useful information on a regular basis, and that's hard, it's not easy to do that on a regular basis. But if we establish with you that we're there, when the time comes, you'll call us because we're good people and we really want to help you. So there's a few minutes left, and I want to be, like I said, diligent about ending this. Are there any more questions?
Not at the moment, but how do they contact you via telephone?
So let me give you our telephone numbers. The Rye office is 914-925-1010. The Yorktown office is 914-245-2440. My email is smd@mfd-law.com. You should be able to get in touch with us very easily. Melanie is the one that answers the phones. My senior associate is Joanna Feldman. She's a wonderful person to speak with. And I'm happy to work with you if need be. Have a really good day.